One of my favourite phrases in British law is ought to have known. Ought to have known is what a reasonable person who holds a position would understand or should understand because they hold that position, not what the person claims inside their head. When someone holds a role with specific duties or power, a director, an employer, a minister, the baseline for what they ought to have known is higher. British law distinguishes between a genuine lack of understanding and willful blindness. Lammy's defence that he didn't know anything about the hunger strikers is not actually a defence in British law. You'd think the Justice Secretary would know that. By now, Lammy has received letters from doctors, from lawyers, from his own Labour MPs, from 200 musical artists across the British Isles. He has been formally notified and the notification is on official records. The government is expected to track such communications through their private secretary office. The failure to respond is itself evidence of his knowledge. You do not deliberately ignore something that you don't know exists. Lindsay Hoyle is the Speaker of the House of Commons. He is an MP that was elected by MPs to chair debates in the House of Commons. He came out on the 10th of December and said that it is totally unacceptable that Lammy refuses to respond to these requests. That is a massive red flag. The Speaker does not rebuke ministers for things that they genuinely don't know. The rebuke itself is further proof that Lammy ought to know. On the 5th of December at a London event, Lammy claimed total ignorance. But this is after his office was formally notified. This is after 51 MPs sent him letters. This is after he received medical warnings from the prison. So does Lammy pass the willful blindness test? He can say he didn't read every letter personally, but a reasonable person in his role has a specific set of responsibilities. He is the Justice Secretary. He is responsible for the counter-terrorism policy. He is responsible for bail decisions. He is responsible for prisoner welfare. In his role as Justice Secretary, a reasonable person, as defined by law, would need to make sure that he is briefed on 1. The Speaker's rebuke, 2. the correspondence from his Parliament, 3. the backlash and building public movement against him, 4. the impact of this counter-terrorism policy on prisoners being held in remand, or 5, at the very least, to have his private secretary warn him of any urgent medical warnings from lawyers, which he has already received. The fact that it was Junior Minister Jake Richards who responded yesterday proves that the issue has reached ministers. You don't instruct a junior minister to respond to 51 PMs without the Secretary of State being aware. The ought to have known doctrine means that his current claims of ignorance are not credible and will backfire. If these prisoners die, any future inquiry will be forced to ask, what did these ministers know or ought to have known? And the warnings, the letters, the press, the parliamentary records, they're very clear. The Empire might try to say, we didn't know we were causing harm, but British law says, well, you should have.